Get it recording. So thank you everyone for joining us today. It's been a couple of weeks since we've had a webinar. I hope everyone had a really nice, safe and healthy 4th of July. So today our main focus of our webinar is going to be on workplace safety. But before we dig into the details, just wanted to provide a few updates. So I'll do a little bit of introduction and background, a few general updates, and then we will talk about workplace safety and touch on some public nuisance lawsuits that are happening. And then we should have plenty of time for Q&A. So as with all of our webinars, we are recording this, and as long as technology works for us, we will post the recording immediately after the webinar on our COVID-19 resources webpage. Please use the chat box throughout the webinar. We have everyone on mute to cut down on background noise to help with the recording, but you can ask questions throughout the webinar. We have National Sea Grant Law Center staff members watching the chat box, and if we don't answer it when your question is posted, we'll come back to it during the Q&A. Just this, I'm sure I recognize everybody's names, so we're just the National Sea Grant Law Center. I'm Stephanie Otts, I'm the director. We're based here at the University of Mississippi School of Law, and as you can see from background, we're still teleworking. We're hoping we might be able to start going back to the office a few days a week in a couple of weeks. But we're here to provide non-advocacy legal research, outreach, and education services to the entire Sea Grant network. And we do have a COVID-19 resources webpage where you can find all of this information. Just some updates from us. So we were able to use our rapid response funding to bring on board 5 new law students who are working part-time for us this summer to provide research into COVID-19 legal issues. And so they're on the webinar with us today. And so I want to say welcome to all of our new law student research assistants. And I hope that you've seen some of their work on our blog. So far they've written 10 new blog posts on a variety of topics, from personal protective gear to the PPP program, workplace safety in general, insurance. So don't forget to follow us on Twitter and Facebook. That's the way, that's the best way to stay up to date about what we're publishing and what's available on our website. And all of that information is posted on our COVID-19 resources webpage. Since the last webinar, the new information is basically our updated Paycheck Protection Program forgiveness tip sheet that we released. Thanks to Texas Sea Grant, there are translated versions of that tip sheet available in Spanish and Vietnamese. So please visit their website for that information. And we also did a summary of the new Small Business Administration interim rule regarding fishing boat owners that I'll touch on in a minute. So that's some of the new things since the last webinar. So specifically for some general updates, as you may have seen, the Congress passed a new law extending the deadline for applications for PPP loans through August 8th. So individuals and businesses now have more time to put together those applications. There is still funding available. That's why the application deadline was extended. Most relevant to Sea Grant is probably the new interim rule that indicated that fishing boat owners can now include some independent contractors in their payroll calculations. So this applies to fishing boat owners or operators engaged in catching fish or aquatic life, and that hired 1 or more crew members regarded as independent contractors or self-employed under 26 USC section 3121B20. And a crew member can fit under this if the fishing boat usually has less than 10 members of an operating crew. The crew member receives compensation as a share of the boat's catch or proceeds from the sale in an amount that depends on the amount of the catch. The crew member generally can't receive additional cash compensation or other compensation for working on the boat. And the boat owner operator must report compensation paid to crew members on box 5 of the 1099 miscellaneous form. So if any of you have been working with boat owners, vessel owners that were considering PPP loans, that is something to look at. We are investigating. We received a question about whether someone who had previously been denied for a PPP loan could apply for one now, since this guidance has changed, and we're working on getting some information out about that. So that's for a loan application. There's also been changes and updates to the Paycheck Protection Program forgiveness, which includes now there's a 24-week loan period up from 8 weeks. There's a new easy application for self-employed independent contractors. And so that information is in our updated tip sheets. And just wanted to mention, there's been a couple of new lawsuits filed that folks might want to watch. There was a class action filed against North Pacific Seafoods related to a quarantine order of individuals that were traveling up to Alaska to work at a cannery. And then a lawsuit filed in Louisiana regarding a wife filed a lawsuit about the death of her husband from COVID-19, and he was a boat captain. And we'll come back to those two cases, but just some things to keep an eye on. So turning to workplace safety, so we are one with the caveat that the National Sea Grant Law Center does not usually do research and work related to workplace safety. So we're providing very general information that we thought might be of interest to both Sea Grant programs, thinking about like how they sit within universities and with their own personnel, as well as from the perspective of individual employees. So we have a lot of different kind of interconnected pieces that we wanted to cover today. And we're definitely interested in hearing your questions and things that may be coming up in your programs that might help us reach out to some people with more expertise to provide more information on these areas if people are interested. So just in general, employers have a responsibility to provide a safe workplace free from serious hazards. And so OSHA, or the Occupational Health and Safety Act, which provides responsibility to OSHA to implement it, covers most private sector employers and employees, either directly or through an OSHA-approved state plan. Importantly, for Sea Grant programs, the term employer does not include the United States, so it doesn't include a federal agency, or any state or subdivision of a state. So OSHA standards do not necessarily directly apply to state universities and employees, and therefore by extension Sea Grant programs. However, state and local government employees may be protected under OSHA approved state plans, and state plans are required to have standards and enforcement programs that are at least as effective as OSHA, although they may have different or more stringent requirements. But in states without a plan, there's no regulation of workplace safety and health in the public sector. But now that doesn't mean that your university doesn't have a health and safety plan and isn't complying with OSHA standards. It just may be that there's not jurisdiction for OSHA to inspect or to issue citations. And it's going to be very different in every state and employer. We thought it might just be useful to show a map of what states do have these plans. And so the states in light blue are just federal OSHA states. So the health and safety standards only apply to private employers. The dark, or like kind of the medium blue, states have a state plan that covers private and state and local government workplaces. So pretty much every workplace. And then there's a handful of states where their state plan only covers federal, state and local government workers. And so the private sector workers would be directly regulated, protected by OSHA, but state and local government workers fall under the state plan. So as I mentioned, it can be very different depending on what state you live in. But because the state plans do have to be at least as stringent as the OSHA standards, thinking about and being aware of the federal OSHA standards are a great place to start, obviously, when you're thinking about what you should do in your workplace to address COVID-19 risks. So in general, under the Occupational Safety and Health Act, the employer responsibilities, these are the 5 key responsibilities, although there are more. Employers have to provide a workplace free from serious hazards. They have to identify health and safety hazards and work to minimize or eliminate those hazards. So employers are supposed to do risk assessments and identify hazards and steps that they can take to eliminate or minimize those hazards. They are to provide personal protective equipment for employees for hazards that cannot be eliminated or mitigated. They're also required to notify employees of identified hazards and provide training on how to address those. So training on how to use your personal protective equipment or measures that you can take to reduce the hazards. And then they have to maintain records and post notices of injuries and illnesses and citations, OSHA citations. In addition to the responsibilities just in general, employers also have reporting requirements. So all employers are required to report to OSHA any work-related incident that results in, among other things, death or hospitalization. And so fatalities have to be reported within 8 hours of the death, and hospitalizations must be reported within 24 hours. The key to think about here with respect to reporting requirements is that it's work-related. So it's limited to work-related. So an injury or illness is considered work-related if an event or exposure in the work environment either caused or contributed to the resulting condition or significantly aggravated a pre-existing injury or illness. Also, these OSHA reporting requirements cover all payroll and non-payroll individuals. So that would include independent contractors supervised by employers on a daily basis. So if you've got independent contractors that come into your workplace on a daily basis and are supervised by the employer, then a work-related incident that resulted in death or hospitalization would need to be reported. So just a screenshot of the OSHA COVID-19 webpage and the link to the where it can be found, although just Google OSHA COVID-19 will take you there. There is a ton of information on their website, including guidance on returning to work, preparing workplaces, but also some guidance for specific industries. So if you are trying to figure out where to start, I would encourage everyone to kind of go and look at the OSHA website and the guidance that they're providing. So with respect to COVID-19, OSHA has not issued mandatory standards or regulations that address COVID-19 exposure in the workplace. There have been calls for them to do so. There have been some petitions and lawsuits that have not been successful to do so. The agency has chosen, at least for now, to rely on the general duty clause and existing regulations. So as I mentioned, employers have a general duty to provide a safe workplace. So an employer could be cited for a violation of the general duty clause, for instance, if the virus was present in the workplace and the employer's efforts to control exposure were insufficient. So they were not doing enough. Or if employees were required to perform tasks that exposed them to the virus without adequate personal protective equipment. And so the agency feels that their existing regulations kind of cover enough of what they need to. They don't need a new regulation specifically for COVID. OSHA has said that the most relevant existing standard is for personal protective equipment. So PPE has been required at workplaces long before COVID. And there is an existing standard for PPE that requires using gloves, eye and face protection, and respiratory protection if job hazards warrant it. Now, there is employer discretion regarding whether COVID-19 infections are work-related. So thinking back to the reporting requirements, they only have to report it if it's work-related. And this could be difficult, right? If you are living or working in an area that has a lot of community spread, how are you going to establish that an individual was infected at work, as opposed to when they go to the grocery store or if they were in church or other places? And so I expect to see maybe some controversy or uncertainty regarding some of these determinations about workplace exposure if there isn't more guidance about how do you determine or how should you determine when infections are work-related. The other thing I wanted to mention that on June 24th, the Virginia Department of Labor and Industry voted to adopt an emergency temporary standard for COVID-19. So this would be different than what the federal OSHA has been doing, which has been relying on existing standards and voluntary guidance. Virginia is seeking to adopt a mandatory standard related to COVID. This was in response to a governor's executive order that required the agency to do so. The guidance is intended to be effective July 15th. And they would be the first in the nation to adopt this type of mandatory standard. Oregon OSHA has also announced work on a standard. They're targeting September 1st. And so I would expect this to increase throughout the summer as well, with states taking additional action. So watch in your state for your Department of Labor or your agency that deals with workplace safety to see if you may be getting state law or regulation with specific mandatory COVID standards for the workplace. Okay. So those are kind of the basic foundation for workplace safety. And turning to now, how might this all come together as we are all returning to work and employers are coming back online after stay-at-home or lockdown orders? So one thing to keep in mind is that employers may require employees to come back to work during the pandemic. So that is just if they reopen, they can call their employees back to work, as long as they are in compliance with the OSHA standards and that they are providing a safe workplace. Now, employees returning to work may have expanded rights to leaves of absence for COVID-related reasons, either under the federal Families First Coronavirus Response Act that expanded some of the federal Family Medical Leave Act provisions, and there's also been some state laws that provide for longer leaves of absences, for instance, if you do not have childcare because your child's school or daycare is closed. Now, refusal to return to work without a valid health-related reason, so if you're in a high-risk category or have an underlying condition, or without a CARES Act justification, well, I should say for the, not the CARES Act, but the Families First Coronavirus Response Act justification regarding childcare, that can be considered as a voluntary resignation. And so you could be, voluntarily quit your job by refusing to come back to work without a valid reason. That can lead to the denial of unemployment compensation for an employee. So there are considerations that employees have to take into account if they are unsure about returning to work when their employers reopen. Now, that said, workers do have rights. So even though employers can require workers to come back, they do have rights under the Occupational Health and Safety Act. So they have a right to receive information and training about the hazards. Workers have the right to be provided with necessary PPE at the employer's expense. The caveat with this is that the employer is the one who determines what PPE is necessary once they complete a hazards assessment. So employers only have to provide their employees with PPE that is deemed necessary to mitigate the risk. If an employee wants to wear more personal protective equipment, they can do so if it doesn't interfere with their job performance, but they would have to pay for that themselves, right? So if you don't like the mask that your employer is providing, you can buy your own. But you can't, an employee can't require the employer to kind of provide what's over and above considered necessary to address the hazard. That said, if an employee feels that they are being exposed to a hazard, they do have a right to file a complaint with OSHA or the state agency that is implementing a state-approved plan if they don't feel that their employer has taken the necessary steps. They can also file a whistleblower complaint with the agency if they suffer retaliation. So employees are not allowed to be fired by their employer if they raise a complaint about workplace safety. And so there's whistleblower protections for such employees. They are also entitled to receive copies of their workplace medical records. So some of the testing and screening that employers might require as individuals come back to work might be considered some form of medical testing or medical records, and workers have a right to receive copies of those things. So speaking of testing and screening, employers may include testing and screening requirements as part of their return to work strategies with some limitations. And those limitations mainly come from EEOC and ADA requirements with respect to discrimination or reasonable accommodation for disabilities. Employers can require employees to be tested for active infections, but they can't require antibody tests. And so the federal government, it slipped my mind which agency has issued the guidance, but antibody testing was deemed to be closer to a medical examination, which is not permitted under federal law. And so employer can't require that, but you can require testing for an active infection because you would want to keep those individuals out of the workplace. And employers can require temperature checks and ask screening questions like, have you had any symptoms? Have you been in close contact with anyone? And so there's a lot of guidance on the EEOC and other federal websites about these type of requirements. And so if you have questions about that, that can be found as well. And just briefly to touch up on a couple things that people may come up with that we are currently researching and may have more information on in the coming weeks. One thing to think about with respect to coming back to work is workers' compensation. So most states require employees who are injured or become ill due to a condition at the workplace, they have to bring a workers' compensation claim, right? Normally, you're not allowed to sue your employer for damages because there's this workers' compensation system set up. Generally, for an illness to be compensable under that system, the employee must have contracted the illness during the course and scope of their employment, had to be related to their job and to the work performed by the employee. So again, because of the uncertainty of how and when COVID-19 is being transmitted and when the illnesses are, when the symptoms are presenting themselves, it's unclear whether COVID-19 will be covered under workers' compensation in all situations, in all cases. Some states have enacted legislation or executive orders that are expanding coverage for certain workers. So you need to be paying attention to what's coming out from your state agencies with respect to workers' compensation about what types of employees and when might be able to file for workers' compensation if they do fall ill with COVID-19 while at work. Another issue that you might hear about are liability waivers. Courts generally refuse to uphold what I've been calling employer-employee liability waivers, where an employer might require an employee to sign a document that says, I'm waiving you of my right to sue or seek compensation as a result of a COVID-19 exposure. And that's generally because those type of waivers are considered against public policy because of the disparity in bargaining power between the employer and the employee. Plus, employers already have liability protections through the workers' compensation system, right? Employees already are not allowed to sue their employer for injuries because they file under workman's comp. So courts generally do not look favorably on liability waivers between employers and employees. Those considerations are different than the considerations for liability waivers a business might use for customers or an entity might use for participants in a public event. And so if you'd like more information on liability waivers, we are conducting some more research on this. You can also see our slides and recordings from May 27th that has more information about that. So turning a little bit more to some of the kind of maybe a few unique situations within Sea Grant. These are just a couple of screenshots of headlines in the last month or so about COVID outbreaks on fishing vessels. There have been guest workers at a crawfish farm that have been alleging workplace safety violations. There was the new lawsuit against North Pacific Seafoods that I mentioned about workers saying they were forced to quarantine without pay, and just a variety of litigation. More is anticipated. I'm sure there will be lots more to come. A couple of things, and I'll talk briefly about vessels and then seafood processing workers. So OSHA has jurisdiction over all workplaces, except in cases where another agency has exercised their authority. And so the U.S. Coast Guard has exercised authority over workplace safety over inspected vessels. So they've preempted OSHA authority with that respect. But OSHA retains authority over uninspected vessels. So there's a bit of uncertainty and confusion likely about who is in charge of what with respect to uninspected and inspected vessels. And we did write a blog post about this a couple weeks ago. The U.S. Coast Guard has issued some COVID-19 guidance for Coast Guard vessels, personnel, and inspections, but the agency has not issued specific guidance for inspected vessels. So guidance that would actually be directed for passenger, cargo, tank vessels, fish processing vessels, those type of vessels. And OSHA has not issued specific guidance for uninspected vessels. So the Coast Guard encourages boat captains and owners to review the CDC guidance and recommendations for best practices for ships. But if you have looked at that, that's seems like it's more designed for cruise ships and large passenger vessels. So it may not be as relevant as we would like. I did find that some states have issued reopening standards for both inspected and uninspected vessels, and some states, including party and charter boats. So Massachusetts and Rhode Island's reopening standards do cover vessels. So please check with your states to see if there is specific guidance about uninspected vessels. And just a quick reminder that workers' compensation is different for seamen who are covered under the Jones Act. And so these are individuals who spend a significant portion of their time working on a vessel in navigable waters as crewmen or captains of vessels. And so the Jones Act is the federal law that gives seamen who were injured on the job the right to sue their employer for personal injury claims. So while most of us can't sue our employers because of the workers' compensation system, that is not true for seamen under the Jones Act. And they are also entitled to maintenance and cure from their employer under traditional maritime law. So the situation for individuals working on vessels is a bit different. And there has been this recent suit in Louisiana by the widow of a captain who died of COVID-19 for damages associated with that death. And so we'll have to stay tuned to see how this type of litigation proceeds and whether courts find some of these COVID-19 related deaths on vessels to be compensable. And then with respect to seafood processing, so the CDC and OSHA did issue interim guidance for seafood processing workers on June 24th. Seafood processing plant workers are considered a component of the critical infrastructure of the food and agricultural sector. Basically, what that means from the CDC guidance is that critical infrastructure workers may be permitted to work following potential exposure, provided they remain asymptomatic, they have not had a positive test result, and additional precautions are implemented to protect the community. So the guidance that CDC and OSHA put out is pretty detailed with respect to at least the type of engineering, administrative management controls that seafood processing plants could implement to try to minimize the risk to their workers. But it's an area that is likely difficult to try to manage, considering the way that seafood processing plants are set up and established. But the guidance outlines potential strategies and controls to prevent the introduction of COVID-19 into the workplace in the first place, which includes quarantine and testing and screening, managing sick workers, educating and training the workers on how to reduce the spread, and cleaning and disinfecting workstations, tools, and equipment. So it's just something to check out if you do work with seafood processing workers or facilities. And with that, we're going to just wrap up the webinar with touching a little bit on public nuisance lawsuits, which is kind of outside of the workers' compensation system. Turn it over to Tara to get us started.
Thanks, Stephanie. Yeah, so as Stephanie mentioned, we've been seeing plaintiffs bringing public nuisance complaints to require their employers to comply with health and safety protocols. And so we wanted to talk a little bit about the doctrine in these cases. The doctrine has traditional roots in land use disputes, and plaintiffs have also successfully used it in cases involving issues like lead paint. But its use in the employment sector is kind of unusual. So we're just going to talk about a few of the cases and what those complaints are saying. So what is a public nuisance? It's generally defined as an unreasonable interference with the right common to the general public. And so the plaintiffs in these cases can be government agencies who are protecting the rights of the public, individuals who suffer a particularized harm from a nuisance, and the particularized harm has to be something different in kind than what is suffered by the general public. And then also those who have standing to sue as a representative of the general public can bring these suits. So in the employment cases that have been cropping up, the employees are alleging that their employer's failure to comply with health and safety guidelines have resulted in a public nuisance. And on the next slide, I'm going to talk about some of the barriers that these suits face, and Stephanie's already touched on some of this. So first of all, regulatory bodies like OSHA typically have jurisdiction over these workers' safety claims. Second, employees' remedy for workplace injury or illness is typically through workers' compensation. And then finally, considering that this is a virus, it's going to be really difficult for plaintiffs to prove that the employer's actions caused the illness. So it's kind of a steep hill to climb, but as we'll see, there have been some small victories here and there. So let's go on to the next slide. So the first case I'm going to talk about is a case involving some Chicago area McDonald's. So in May, 5 workers and some of their family members sued the McDonald's Corp and then several franchisees, alleging that the working conditions there amounted to a public nuisance. The employees claim that McDonald's failed to take steps to protect them from COVID-19. They had no adequate protective equipment, hand sanitizer, or safety training. And then on June 3rd, the Illinois judge denied McDonald's motion to dismiss. So that was kind of a win. They rejected McDonald's argument that the regulatory agencies like OSHA have primary jurisdiction. And then the next case also involves, let me go back, I'm sorry. On June 24th, the judge also partially granted the employees' request for a temporary court order requiring virus precautions while the case is pending. So that was also a win. The judge found that the McDonald's was adequately following protocols on using hand sanitizer, but they were not enforcing mask requirements or adequately training their workers on social distancing. So the next case there is about McDonald's in Oakland, California. There, the employees filed suit alleging that the restaurant's safety failures included offering masks made of coffee filters and dog diapers. So that was kind of unusual. And on June 22nd, the judge in that case issued a temporary order requiring the location to implement additional safety measures, including social distancing, temperature checks, and providing sufficient masks and gloves while the case is pending. And then the next case, it involves Smithfield Foods. Employees of a pork processing plant in Missouri filed this suit against Smithfield, saying they were not adequately providing them protection against COVID-19. They sought an injunction to require the employer to comply with CDC guidelines and Missouri public health orders. They alleged that they had inadequate PPE, they were forced to work in close quarters, and they had insufficient time to wash their hands. Smithfield filed a motion to dismiss that complaint. They argued that OSHA had jurisdiction over the workers' claim. And although the judge ordered the company to follow OSHA, CDC, and other guidelines while the case was pending, the judge ruled in favor of Smithfield and dismissed the case. The court agreed that OSHA had primary jurisdiction over the claims. So as you see, it's kind of a mixed bag as to what these judges are saying. In that case, I will say OSHA began investigating the employees' claims in April. And I saw that they had subpoenaed Smithfield asking for the production of documents related to the investigation, and the company has filed a motion in federal court to quash that request. So they aren't exactly cooperating. And then the final case is an Amazon case. Some Amazon warehouse employees filed suit in federal court alleging the company did not follow CDC guidelines, and they sought an injunction to require them to do so. The workers claimed that Amazon punished those who spoke out about health concerns and didn't promptly pay employees for sick leave, and they were preventing them from engaging in the hygiene practices that were necessary. So there really hasn't been any action in that case. I think they are currently reviewing that complaint. So that's kind of a mixed bag there. So next, I just wanted to mention, what employers can do in response to these public nuisance claims. To manage the risk, the best thing they can do is to make good faith efforts to protect employees. That will be given considerable weight by the courts. They should follow the procedures outlined by the CDC, OSHA, individual states, and local governments. And then that would provide an important defense to some of these lawsuits, and also protect the employees, the most important thing. So that's all I have.
Great. Thanks, Tara. So, I forgot to update the slide. We don't have any poll today, but we hope that this information has been helpful, that it may have addressed some of the questions that you're receiving or your programs are discussing with respect to workplace safety. Please feel free to use the chat box to ask any questions or share thoughts. You can also contact me or any of the staff from the National Sea Grant Law Center at any time by email with your questions. As I mentioned, our law student research assistants are working right now to research a lot of the topics that we addressed today in more detail. And so we are happy to try to get answers for whatever questions that you are facing. So I'll give folks a minute or two to see if we get any questions. And if not, I thank everyone for joining us, and we will post the recording as soon as we can. Well, I don't see any questions coming in, so I want to wish everyone a great afternoon, and thanks again for joining us.